Welcome. Thank you for joining us today. My name is Carol, and I am the president of the Senior Counsel Division for this year and for the third time. We glad you can join us. This is our first Senior Counsel Division Coffee Hour of 2021, and today's topic will be the fundamentals of trust, asset protection planning, and healthcare planning. And we have none other than our very own board member, Senior Counsel Division, Scott McCullough, who has practiced in this area since 1983 to educate us about all of these really, really important topics, especially nowadays. Scott is a graduate of the William S. Richardson School of Law, my alma mater as well, and also Duke University and Kapu High School. He's also been a valuable volunteer for the Senior Counsel Division, and I've had the pleasure of working beside him in our neighbor aisle clinics. Would ask that if you could please hold your questions until the end of the presentation and then put it in the chat box, because Scott will be busy with his presentation as well as his PowerPoint. So please hold your questions towards the end and then put it in the chat box, and then they will be, read off so that he can assist people with questions. And one last thing, please mark in your calendars February 4th. That will be our next Senior Counsel Division coffee hour at noon. And we have a new and interesting presentation on virtual mediation. So if you put that down on your calendars. And now I'm very pleased to welcome Scott McCullough, and he will be talking about asset protection and estate planning. Thank you, Scott.
Aloha. Thank you so much for inviting me to speak. I'm going to try and keep the presentation relatively brief and straightforward and leave plenty of time for questions at the end. So hopefully we can have a little bit of interaction in that way toward the end. One of the things that I found about Zoom presentations is they're really difficult because there's not a lot of give and take between the presenter and the participant. So please just bear with me, and we'll make this the best we can. So when we talk about planning, there's pretty basic consideration that we start with. And by the way, before I get going, would everybody mind please muting your microphones? There's background noise right now. But if everybody could mute, that would be great. So first question when it comes to estate planning is, why do we do it? And a lot of times the assumption when it comes to estate planning is, well, we do it because we want to minimize taxes. We want to avoid probate. We want to do various things when it comes to our stuff. Stuff, of course, being the technical legal term that Carol and I learned at the William S. Richardson School of Law. That means everything you own. Now, your stuff is important, no question about that. But there are things that are more important than your stuff, including you, including the people who would be affected if something happened to you. So really, the why behind estate planning is people and how people are going to be affected in various contingencies. Okay, so if the why is people, what can we do? Well, one of the kinds of things we can do is we can appreciate the fact that there's lots and lots of rules out there. There's rules about which side of the road we drive on. There's rules about taxes. There's rules about what makes a valid will or a trust. Well, when it comes to estate planning, the really great rule is we get to write our own rules. So what our estate plans end up being are the rule books that cover things like, well, what if there comes a time when I can't manage my stuff for myself? Who's going to do that for me? What if there comes a time when I can't make decisions about my medical care? Who's going to do that for me? So our estate plans are the collections of rules that we put together to make sure that those kinds of contingencies are going to be covered. So how do we do it? Well, estate planning really is a process. It begins with sitting down and figuring out where we are now, figuring out what our objectives are going to be, and then creating the rule books that are going to get us and our loved ones from where we are now to our objectives. And one of the really critical things we have to remember is that along the way, things are going to change. Our family situations are going to change. Our finances are going to change. The list of people that we like and trust and would want to have making decisions for us is going to change. And so one of the things that we need to bear in mind when it comes to estate planning is that we need to make room for reviewing the estate plan from time to time and making appropriate adjustments so that we can make sure we're staying on course and that our estate plan is going to do exactly what we want it to do. Now, I tried to emphasize at the very beginning that your stuff is important, but there are things that are more important than your stuff. Tax planning is important, and minimizing taxes and avoiding probate. All of those things are important. But what I think is more important than anything else, going in the wrong direction, is maintaining control over our stuff, maintaining control over who gets to make decisions for us. So in my estimation anyway, control is a much better foundation for an estate plan than the tax considerations or the probate avoidance considerations. So what's next? Oh, my mouse is giving me a little bit of a hard time. So the next step up the planning pyramid is providing for me. Oh, and don't forget my spouse. I didn't, I promise I didn't. The reason I have her in parentheses there is just to emphasize the point that in our estate plans, we really do have to take care of ourselves in order to be in a position to take care of other people. It's kind of like when you take a plane trip and you get the safety briefing at the beginning and they tell you about the masks. Now, I've never been on a flight where the masks appeared other than during the safety briefing. I pray I never am. But if I do, I know what to do when the masks appear. I grab it and I put it on the person next to me, right? No, that's exactly wrong. You put it on yourself first. And it's not because you're selfish. It's because if you're unconscious, you're not going to be in a very good position to help anybody else. So the point being, you got to take care of yourself in order to be in a position to take care of the people who, figuratively speaking, are sitting around you. Next step up is providing for other family members. And other family members could include the ones with 4 legs and a lot of fur or feathers or scales, or taking care of our pets. It may mean providing for our favorite charities, but there are other obviously entities and factors that come into the estate plan at that point. And then the tip of the pyramid is minimizing those taxes and expenses. So that is important. We want to do it, but we don't want that to drive the estate plan. So here's a definition of estate planning that I'd like to propose. Point 1, I want to control my stuff while I'm alive and well. I've never had anybody object to that one. We all want to be in control of our stuff. Point 2, plan for me and my loved ones if I become disabled. Now, I got some good news and some bad news. The good news is we kind of know what the percentage odds are of any one of us becoming completely incapacitated for some period of time before we die. The bad news is that percentage is about 70%. So if disability planning isn't part of your estate plan, it really ought to be. There are important things that we can put in place. And I'm not really going to talk about those today. I'm talking more about stuff and how to plan with respect to stuff. But I don't want to underemphasize how important disability planning is in our estate plans. And then ultimately, I want to give what I have to whom I want, when I want, the way I want, and when I die. And here, unfortunately, the percentage is 100%. I want my stuff to go to the people I love without unnecessary cost or delay or loss of privacy. So how do we do those things? Well, one approach is to do nothing. And if you do nothing, no problem. The state of Hawaii has written a will for you. The will is called the law of intestate succession. Now, the law of intestate succession basically says that your stuff goes to your closest family members. It goes to your heirs. And, that doesn't sound like such a bad idea, but let's take a look at the kind of things that can happen. And we're going to do that in just a moment. I just want to go through the various approaches that we're going to be talking about. The next is joint tenancy, tenancy by the entirety. It's owning assets in ways that just by operation of law, because of the way we hold title, that title passes to the surviving joint tenant or joint tenants or the surviving tenant by the entirety, which under Hawaii law is a spouse or a reciprocal beneficiary. So we'll talk about those in a little bit more detail. Beneficiary designations, not going to go into that in a great deal of detail, but you know how they work. Beneficiary designation is when you buy a life insurance policy, for example. One of the things you got to do is say where the money's going to go if something happens to you. You can also designate beneficiaries on bank accounts, annuities, retirement plans. And it's really important to make sure that all of those beneficiary designations line up with the overall estate plan. And from time to time, your desires with respect to the beneficiary designations may change. So you need to bear in mind that one of the kinds of things that you would do during what I suggest, at least an annual review of your estate plan, is take a look at those beneficiary designations and make sure they still say what you want them to say. The next would be will-based estate planning, and then finally, trust-based estate planning. So let's look a little bit into the state's will, the law of intestate succession. Well, another thing that Carol and I got to learn in law school was what we call the two-finger test. And what you do with the two-finger test is you take your index and your middle finger on your right hand, and you apply them to the inside of the wrist on your left hand. And hopefully what you feel is this bumping sensation. What that bumping sensation means is that we don't know where your stuff is going to go if you check out anytime soon. If that bumping stops, we don't know where your stuff is going to go. The law says it's going to go to your heirs, but who is that? You don't know until you're dead. So it's important to appreciate that and kind of think ahead. Do you really want your stuff to go to whoever the law says it's supposed to go to upon your death? Well, here's a little bit of a horror story that can happen as a result of intestate succession, and it's a true story. Mom and dad had one child, a daughter, and mom and dad unfortunately split up. Dad found someone that he would rather be with than mom, so he left mom and married this other lady, and Mom, of course, wasn't very happy about that, but mom didn't do anything when it comes to her estate plan in light of that circumstance. So what eventually happened is mom passed. The law of intestate succession said that her stuff goes to her heirs, and her closest heir was her daughter. Daughter, unfortunately, subsequently died, and daughter had no will. The law of intestate succession said everything went to her dad, who is now married to someone other than mom. Well, dad died without having done any estate planning, and all of dad's stuff ended up going to dad's second wife. So the bottom line was mom's assets passed to the lady who she considered a home wrecker, which was certainly not mom's intent or what mom would have preferred, but just by the whole family leaving things to chance and leaving things to the law of intestate succession resulted in something very much other than mom would have what mom would have wanted to accomplish with her estate plan. Now, intestate succession brings into play all of the probate complications and all of the problems with probate that we're familiar with. Probate can take a long time. It can be expensive. It can be really aggravating for those kinds of reasons. Probate is a public proceeding. Anybody who wants to can go down and look at the file and just find out things about you and your stuff and your family and do things with that information that you may not want them to be able to do. So doing nothing really has a lot of serious problems. Well, okay, so what if instead of doing nothing, at least we put somebody else on title to our stuff so that it'll pass to them by way of joint tenancy? I like to call that poor man's estate planning because joint tenancy, of course, is, I mean, it doesn't cost you much, if anything, to accomplish. So why not just put someone else on title to all your stuff? Well, let me tell you another horror story. This one is fictional, and you may recognize that by the names of the main characters being Mo, Larry, and Curly. Mom and dad, let's say, have 3 sons, and for whatever reason, they name them Mo, Larry, and Curly. And mom and dad find out that joint tenancy is a wonderful way to leave assets to your family members because all they have to do is outlive you in order to get your stuff. So mom and dad put their 3 sons, Mo, Larry, and Curly, on title to their house, on title to their bank accounts, on everything they own that has a title document attached to it. And everything actually goes fine for 5 years. 10 years go by, everything's fine. But then there's that one fateful day when Mo comes running in the house. Mom, Dad, got a problem. Well, my wife has left me. She wants a divorce. And, you know, she seems to think she's entitled to half of everything I own. Now, I seem to recall, what was it, maybe 10 years ago, you guys put me on title to the house and on your bank accounts and on all your other stuff. Do you think this divorce thing is going to create any problems for the family? A few minutes later, Larry comes running in. Mom, Dad, got some bad news. Remember that car accident I was in about 3 years ago? Well, thing is, at the time of the accident, I didn't have the money to pay my insurance premium. So I didn't have any insurance to cover the accident. And it turns out it was my fault. And these folks have gotten a judgment against me. And they're trying to enforce the judgment against my assets. And, you know, I seem to recall, was it 10 years ago, you guys put me on title to the house and on your bank accounts? And gosh, do you think this is going to be a problem? Well, yeah, actually, in both cases, it is going to be a real problem. In Mo's case, we've got the ex-spouse, and I call the ex-spouse here a predator, and she may or may not be that, but in Mo's case, that's certainly the way he feels. And she's going to be able to reach into the assets that Mo owns, including mom and dad's house, potentially, in order to enforce whatever claim she has in connection with the dissolution of the marriage. Larry, likewise, has a real problem because he's got people who got a judgment against him because of that car accident. And are those folks going to be able to perhaps get their hands on the house, get their hands on mom and dad's bank accounts? Well, yes, by virtue of the fact that Mo and Larry are on title to those assets. Their creditors, the predators who would be coming after them, can access those assets as well. And then don't forget, we've got Curly. And Curly falls within the very special category of beneficiaries that we call the baboos beneficiaries. These are the folks who, you know, they may be really wonderful people, but they can't hold on to assets. Maybe they got bad friends, bad habits, whatever it is. They're just not going to make any kind of a windfall last for any length of time. And actually, there are statistics on how long windfalls last in the hands of the windfall recipients. At last tabulation, that was about 17 months. And it turns out that it doesn't matter the size of the windfall. People run through it pretty quickly on average. Remember that 17 months is an average. So joint tenancy has some very distinct disadvantages to it. It's not that we never use it in estate planning, it's just that it has to be used advisedly. Okay, what about tenancy by the entirety? Tenancy by the entirety is a very special kind of ownership that the law of the state of Hawaii allows you to have with a spouse, a reciprocal beneficiary, a civil union partner. So it's limited between spousal types of parties. So husband and wife, for example, can take title to assets as tenants by the entirety. And that's got some really special aspects to it. One of them being that which was explained in the Hawaii Supreme Court case of Sawada versus Endo. In that case, Mr. Endo was cruising along, I believe it was in Hilo, and had a very serious accident with another car that had several members of the Sawada family in it. And Mr. Endo went home, told his family about the accident, and they all said, well, gosh, you ought to transfer the house out of your and mom's names to the kids because these folks are going to be coming after you and they're going to take your house away from you. So dad did that. Mom and dad signed deeds and they conveyed the house to the kids. Well, as the Sawadas perfected their claims against Mr. Endo, they took him to court, they got a judgment, they tried to enforce it. And when they started looking for assets, Mr. Endo said, well, yeah, I used to own a house, but right after the accident, I didn't own it anymore. And the Sawadas felt that that was what the law calls a fraudulent conveyance. And they wanted to get the house back into Mr. Endo's name so that they could enforce their claims against it. Well, the case went up to the Hawaii Supreme Court, which said, you know, it might not have been the most wonderful thing that happened, that, you know, Mr. Endo transferred the house away, but it didn't harm the Sawadas at all because Mr. and Mrs. Endo owned the house as tenants by the entirety, which meant that creditors of Mr. Endo could not enforce their claims against the house. Now, the backstory to that is that if Mr. and Mrs. Endo had known about the Sawada versus Endo case at the time and said, oh, well, no problem. We can just leave the house in mom and dad's names because the Sawadas can't get at it. Well, Mrs. Endo died before Mr. Endo. So as soon as Mrs. Endo died, dad would have owned the house, and then that would have been up for grabs by the creditor. So it was actually kind of fortunate that they did what they did. But Sawada versus Endo, very important protection. It's not universal. This is a Hawaii case and it applies to Hawaii tenancy by the entirety. Another interesting case is the Dean Trust case. And in Dean Trust, this is dicta, it's not part of the holding of the case, but the Supreme Court said that, you know, in the case where husband and wife or parties to a tenancy by the entirety have an asset and one of the parties dies, the claims, any claims against the deceased party are not enforceable against the surviving spouse. And that's actually part of Chapter 572 of the Hawaii Revised Statutes. But in the Dean Trust case, what the Supreme Court said was that, yeah, even when it comes to tenancy by the entirety property, let's say in this case, Mr. Endo had died first, the folks who had a claim against him still couldn't enforce the claim against that tenancy by the entirety property when the one spouse died and the other spouse received it. So Dean Trust tells us that the Sawada versus Endo protection can continue beyond the death of one of the spouses or one of the owners of the tenancy by the entirety property. Now, up to about 10 years ago, it was the general consensus that if you took your tenancy by the entirety property and you put it into your revocable living trust, you lost the tenancy by the entirety protection. And our legislature was good enough to change the rules when it comes to tenancy by the entirety to make it clear that you can take your tenancy by the entirety property and split it between spousal trusts, or you can put it into a joint trust, and you can keep that tenancy by the entirety protection as long as you include the right magic language in the deed and presumably in the trust agreement as well. So there are things we can do to plan for that tenancy by the entirety, even when we're using trust planning as part of our estate plans. Now, what exactly is a trust? Well, a trust is something that's handed down to us by the English common law, and its roots date back into medieval England, But the bottom line when it comes to a trust is it divides the ownership of an asset between the legal component, the title holding component, and the beneficial or the enjoyment, or what the law calls the equitable component. The elements of a trust are these. You have a trust maker, at least that's what I call the person who's setting up the trust. The trust maker makes an agreement with a trustee to manage some stuff for the benefit of one or more beneficiaries. And the instructions to the trustee are set out in that portion of the rule book, the estate plan, called the trust agreement. Now, there's lots and lots of kinds of trusts out there. The main categories being testamentary and living. Testamentary trust, of course, is one that you create by the terms of your last will and testament. And there are a lot of great examples of testamentary trusts out there. One of them is the Bishop Estate. It's governed by the will of Princess Bernice Pauahi Bishop. It's a great example of a testamentary trust. Another is the Campbell Estate, which if you've lived in Hawaii very long, you know that it had to be wound up a few years ago because the Campbell trust could only last for the length of the rule against perpetuities. The rule against perpetuities expired, the trust had to terminate, and the assets had to go out. Now, testamentary trusts are really good for providing for management of your stuff after you're gone. Now, whatever goes into the testamentary trust, of course, has to go through probate, so that may not be a great thing. And another thing about testamentary trusts is they don't do anything for you or your family while you're still alive. They can't. By definition, you have to die in order for your testamentary trust to come into play. So most of the time, nowadays, we don't use testamentary trusts. We use living trusts. There's one application for testamentary trusts that is still commonly used, and that's in the Medicaid planning area. But for the most part, the preferred kind of trust is the living trust. Now, living trusts also break down into a lot of different categories, but the main ones are revocable and irrevocable. The revocable trust is one that you can change during your lifetime. And what I like to use as sort of an illustration of a revocable trust is a little red wagon. We all know what a little red wagon looks like and how it works, because if you didn't own one, you know somebody who did, and you probably played with their wagon. So you know that it's very easy to put assets in and take assets out. And when you're playing with a little red wagon, your asset may be your teddy bear. When you grow up and create a revocable living trust, the assets would be just about everything you own. You might want to put your house, your bank accounts into your trust. You might want to name your trust as beneficiary of life insurance policies. Because of recent changes in the law, you may not want to name your trust as beneficiary of retirement plans. There are some circumstances where it still makes sense to run retirement plans through your revocable living trust. But most of the time, it makes more sense just to go ahead and name the individual beneficiaries, name the kids, well, name the spouse primarily, and then perhaps the kids or charity or grandkids or whoever you want as the contingent beneficiaries. Now, one of the things about the little red wagon is it sort of illustrates the fact that you can reach into that little red wagon anytime you want and pull assets out of it. If you can reach in there, your creditors can too. Whatever you can touch, your creditors can touch. So the revocable living trust provides really no asset protection for you. But as we're going to see in a minute, it can provide some really neat asset protection for your kids, your surviving spouse, your other beneficiaries. Now, the irrevocable trust, in contrast to the revocable, imagine a box with a lid on it. Now, what the lid signifies is you can't reach in there any old time you want. Because of the terms of the rule book, because of the terms of the agreement that governs the irrevocable trust, there are limitations on your ability to get back in there. And those limitations are really important because your inability to get in there also means your creditors can't get in there. As long as the trust is set up right, you can actually create an irrevocable trust to protect your assets against your creditors. And this is a pretty recent development in Hawaii law. The classical rule is you can't do a self-settled spendthrift trust. In other words, you can't set up a trust to protect your stuff from your own creditors. Well, that's the good old days. Now you can. Hawaii has a specific statute, and a lot of other states do too. Now, one of the things to be very careful about in dealing with those various state statutes is they purport to provide really wonderful and universal creditor protection. But we learned recently, as a result of an Alaska Supreme Court case, that it might be just a little more provincial than the law seems to imply, meaning that in that Alaska case, what the Alaska Supreme Court said was that an Alaska Asset Protection Trust set up specifically under the Alaska statute that deals with these things is great for protecting the assets of Alaska residents, but it doesn't necessarily apply to people from anywhere else. Now, the Alaska trusts and trusts in other jurisdictions as well have been sold to people across the country with the idea that you can set up your trust in Alaska or one of these other asset protection jurisdictions and have this wonderful protection under the law. But it turns out that that may not be the case. So if you're a Hawaii resident, probably if you're going to do one of these asset protection trusts, you're going to want to do it pursuant to Hawaii law. Now, that doesn't mean that you can't take your irrevocable trust offshore and create a trust under the law of a foreign jurisdiction, like the Cook Islands or the Cayman Islands or the Channel Islands or the Isle of Man. There's a lot of asset protection jurisdictions. And what they do basically is rely on their remoteness to protect your stuff. Because, for example, under the law of the Cook Islands, if you want to get a judgment against someone who has an irrevocable trust that's situs in the Cook Islands, you actually have to go to the Cook Islands. You have to get in front of a judge in the Cook Islands and get a judgment against the person who has the irrevocable trust before you even have a shot of trying to get into that trust. And there is a statute of limitation that once you've had your trust in the Cook Islands for, and I haven't double checked the statute, but at my best recollection, it's a year and a half. So once you set up your trust, you've had it there for a year and a half, that statute of limitations bars any kinds of claims against the assets of the trust. So going offshore has its own expenses, it has its own risks, but in appropriate circumstances, that can be a really great way to protect assets from creditors. Now, when it comes to planning through trusts, there are a lot of objectives to be accomplished in addition to asset protection, one of them being incapacity protection, that is protecting against your own incapacity. And one of the things that we all have to be concerned about is the day when perhaps we're not able to manage our trusts as well as our family would like and as well as we would like. And those times come along unless there's some kind of a catastrophic event. The person who is losing capacity doesn't necessarily want to admit it. They don't necessarily want to give up control. It can be a good idea, therefore, to build in a provision into your revocable living trust agreement that gives people that you trust and would only make the call in appropriate circumstances, but give them the ability essentially to fire you as the trustee of your own trust. And that can resound to the benefit of you. It can resound to the benefit of your family. I've actually seen a situation where a senior family member developed Parkinson's and lived long enough after that to become severely demented, but before he died, he made some very bad decisions with respect to the family assets, and he made a large estate, a small estate, with just a couple of very bad decisions. There was nobody who could stand up to him and say, hey, Granddad, you shouldn't be in charge anymore. We need to move control to somebody else for your own good and for the family's own good. So just for your consideration, you might want to build in a provision into your own revocable trust that gives somebody the ability to pull the plug on your trusteeship if there comes a time when you're just not able to be a good trustee. Remarriage protection is something else that we can consider in our estate plans. And that is there's no reason that you have to leave everything you own to your spouse, who then remarries and dies, leaving everything to the new spouse, kind of like that intestate succession example that I gave earlier. And then the assets end up going to the new spouse's kids to the exclusion of your kids. So there's a variety of protective things that we can build into our rule books to make clear that our surviving spouse perhaps would be benefited for life, or at least for as long as they stay single. But then what we leave behind, whatever's left when spouse is done with it, is going to go to our kids, not the next spouse's kids. Creditor protection is something that we can build into our revocable trusts for the benefit of our survivors. So for example, when you die, your trust becomes irrevocable. When you become incapacitated, your trust becomes irrevocable, because under your trust agreement, you're the only one who can change it or revoke it. So once you lose that ability, it becomes irrevocable. And it takes on a lot of those wonderful creditor protection aspects that I was talking about earlier with the irrevocable trust, at least for the benefit of the people we leave behind. So we can make sure that our spouse, our kids, grandkids, whoever we leave assets to, receive the assets in a way that's going to be very, very defensible against people coming and trying to take them away. Now, to do that, we've got to build in a certain level of complexity, and that humbug factor can be a deterrent to doing creditor protection in our estate plans, because among other things, one of the great ways to protect your stuff is to have it go to your descendants, have it go to your surviving spouse by way of a trust that says, well, look, I want to give you a lot of control over this, but I don't want to give you so much control that people are going to be able to come and take away your inheritance. So although I'm going to give you the power to make investment decisions, to make decisions about, let's say, distributions to your kids or anybody but you, but when it comes to making a distribution to you, you've got to have a neutral third party as the trustee who makes the determination that that distribution is going to be made. Now, neutral third party can be kind of a spooky term, except when you consider that a neutral third party under the law for asset protection purposes is simply anyone who's not a beneficiary or the beneficiary's spouse, parent, descendant, sibling, or employee. Or as we would say on the Big Island when I was growing up, it's not mara fara sista brada or a worker. It's anybody but that. So it can be best friend, it can be cousin, it can be favorite uncle, it can be a bank or a trust company. And we can actually give the beneficiaries the power to remove and replace the trustee at will. So with that authority, really, our beneficiaries are in charge of the trust. They control the trustee, they control the trust. Now, at the back end, when the beneficiary passes on, we can give the beneficiary what's called a power of appointment that says that whatever is left in the trust goes wherever the beneficiary says. And we would say in the trust agreement exactly how that power of appointment needs to be exercised. So you may see in some trusts, you may see the requirement that the power of appointment be exercised by way of a will. But it doesn't have to be by way of a will. It can be by way of a trust agreement or just a separate document called an exercise of power of appointment. The point being that we can give our beneficiaries control over their inheritance during their lifetime. We can give them control at death. And there's a sacrifice of a small amount of humbug, that is having to bring in that neutral third party trustee. But that humbug really becomes worthwhile if things melt down and there really is a serious creditor situation. So something to consider. Divorce protection. When we leave assets to our kids, most of the time we want to make sure our kids are benefited and not our kids' ex-spouses. So by leaving assets in trust, we can provide protections that are going to minimize the access, if any, that an ex-spouse is going to have to come after the inheritance. Special needs is another thing that we need to consider when it comes to our trusts. We may not have any special needs beneficiaries now, but who knows, by the time we pass or by the time our children pass, are there any beneficiaries who are going to be in line to receive assets who are receiving governmental benefits? If we have assets go to those individuals, they may lose those benefits. And that could be really critical, because what that may mean is that the beneficiary essentially has to lose their benefits, burn through their inheritance, and then try and reapply for benefits later on. Are they going to be able to get those same benefits? Are they still going to qualify? Are those programs still going to be in effect? Hard to say, but it's generally a better practice not to cause people to lose their benefits. And one of the ways we can do that is by building in special needs provisions into our trust agreements that are just sort of there for emergency purposes, that say that if, for example, that if any assets are going to go to a special needs beneficiary, then special rules come into play, among them being that the beneficiary can never be a trustee over those assets, and that the assets can only be spent on the kinds of things that the governmental benefits don't provide. So special needs planning can be a really critical thing that goes into our revocable living trust planning. And then finally, one of the things that we can do is promote our own values through our estate plans. And by that, I mean, we can encourage or discourage certain kinds of behavior by conditioning the distributions out of the trust on certain events. So for example, on the negative side, we can say that in order for a beneficiary to get a distribution from this trust, they got to pass a drug test. If they don't want to take a drug test, no problem, but they don't get a distribution unless they do. So obviously that is going to discourage certain kinds of behavior. We can also encourage certain kinds of behavior by saying things like, well, I'm want a certain pool of assets to be set aside to pay for my kids' college education. And once they've attained a degree, they're going to get a special distribution. There's going to be this bonus. And by golly, it may be enough to buy a car, or it may be enough that it would be a real incentive to our kids to go ahead and get their degree, finish college. And we can put whatever conditions we want on that. We can say, yeah, you get the bonus when you get your degree, but you got to get your degree in 4 years, or however you want to build the incentive. The point being, it's your rule book. You can build it any way you want. Want to say before we start opening up for questions that there's been a little bit of movement in the rules that deal with federal and state estate taxation. The primary one being that the coupon amount, I call it the coupon because it's kind of like they give you a coupon that covers a certain amount of assets before the estate tax kicks in. The IRS actually calls this the exemption equivalent. But what that exemption equivalent or that coupon works out to is $11.7 million as of this year. It was just increased by an inflation adjustment. And just in case you were wondering, the gift tax exclusion of $15,000 stays the same in 2021 as it was in 2020. But the estate tax exclusion has gone up. It was about $11.5 million. Now it's 11.7. And remember, this is per person. So husband or one spouse can pass on $11.7 million, no estate taxes. Surviving spouse can also pass on $11.7 million, no estate taxes, which means that for most of us, as long as we die while these rules are in effect, we're not going to have to worry about estate tax. The catch is that the rules that resulted in the increasing estate tax exclusion go away in 2026. So as of then, the estate tax exclusion goes back to what it was before the current law, and that is it'll go back to $5 million, perhaps adjusted for inflation between 2016 and 2026. I'm not actually positive as to whether that inflation adjustment would come into effect in 2026. But the exclusion is going to go all the way down to 5 million. Now, 5 million is still a lot. And for most of our clients and for most of us, probably that's still not an issue. estate tax isn't going to be an issue under the current rules or the rules that are set to go into effect later on. Now, in the meantime, there's nothing to prevent Congress from saying, well, we like the big exclusion. We're just going to keep it and we're going to let it ride and let it keep increasing with inflation. Nobody knows what's going to happen in the next 4 years. A lot could. That exclusion is a matter of basically whatever Congress wants to make it. So it could be a lot lower, it could be higher. We don't know. That's one of those kind of things that we have to keep an eye on for ourselves and for our clients and make sure that we're going to be okay at the end of the day and our families are going to be okay. Now, once you go over the exclusion amount, whatever it is a tax that hits at 40%. The federal tax is just a flat 40%, which obviously is a huge tax. And it's due within 9 months of date of death. It's payable in cash. The IRS does not accept real estate. They do not accept chickens. You gotta pay in cash. And so for some estates, liquidity planning can be a real issue, making sure that there's gonna be enough liquid assets in the estate to pay whatever expenses and whatever taxes are gonna be due at the end of the day. Portability is a neat thing that came in 2016, and that is that between husband and wife, if they, let's say they kind of keep their assets separate. Let's say I bring $1 million into my marriage and my wife brings $30 million into the marriage. If I go first, I've got an $11.7 million coupon, but that means I've got a $10.7 million waste of coupon that I couldn't use because I only had $1 million. Well, what portability tells us is that as long as my wife files an estate tax return for me, even though it's not required under the law, she can port over my unused exclusion and she can apply that against her estate later on. So portability is a pretty cool thing. It's something to keep in mind. And then finally, the Hawaii estate tax kicks in at $5.49 million. So just kind of the same way that federal coupon works, the Hawaii coupon is worth about half of that. It's about $5.5 million. Hawaii originally sort of tracked the federal coupon, but then later on decided, nah, that's too much for Hawaii residents. Let's make sure that we can tax at least some of them. So they lowered it down to the 5.49. It's not been adjusted upwards as of 2021. So need to bear in mind that when we're working with an estate that has an estate tax problem, the estate tax problem is actually a lot lower or has a lot lower threshold than the federal estate tax. And so sometimes planning for the Hawaii estate tax may take precedence even over planning for the federal estate tax. The way you would do that is you'd use a lot of the same techniques, but it's important to bear in mind that the Hawaii coupon and the federal coupon are different. And for clients who own assets in other jurisdictions, say California or New York, they also have much lower coupons than the federal coupon. So there can be, depending on the nature of the assets, there can be a state estate tax for states that do not have a federal, or in the case of an estate that the federal estate tax isn't relevant. So with that, I'd like to open up for questions, and we've got about 10 minutes. And if there are no questions, great, we can all grab some lunch. But I'd be happy to try and answer whatever questions folks have. And I think we've got somebody monitoring questions and they're gonna feed them to me, and I'll try and answer them as best I can. So Carol or?
Brian, are you there?
Yes. So first question, what effect of couple when each have separate trusts, each own half the house? What happens when one spouse passes?
Yeah, and that is a really common technique for minimizing estate tax, but also for providing creditor protection for a surviving spouse. So each spouse, as I said earlier, has their own coupon. So in my case, let's say I die first, I've got this $11.7 million coupon. And not to go into too deep of self-disclosure, but I can tell you that the 11.7 more than covers everything I own. So what would happen is my wife probably would want to go ahead and file an estate tax return on my estate, and whatever was in my trust then would be covered by that exclusion. And that would be true no matter how long my trust lasts, which means that, let's say I start out with $1 million estate when I die, and I've got an $11.7 million coupon. But then my trustee, let's say my surviving spouse, decides, hey, let's invest in something really cool like Plug or Pinterest or one of these wonderful stocks that's just exploded in value. And my $1 million becomes $20 million. Well, later on, when that trust terminates and the assets go out, they're still sheltered from the estate tax because at the time of my death, they were within my coupon amount. I hope that answers the question.
Okay, next question. What did you mean when you said earlier that testamentary trusts have to pass through probate?
Yeah, in order for a testamentary trust to exist, a will has to be admitted to probate, and the assets have to go through the probate process in order to end up in that testamentary trust. So testamentary trust, like I said, is great for providing for management, but it doesn't avoid probate. Whatever goes into the testamentary trust is going to go through the probate process. The will that creates the testamentary trust is going to need to be probated. So yeah, the testamentary trust, great for certain purposes, not great for avoiding probate. It's just the opposite of avoiding probate.
Also, the risk that you can't find the will.
I'm sorry, I actually have a studio audience and somebody's chiming in here. What did you say, Tom?
Also, the risk that you can't find the will.
Oh, well, yeah, another risk, I guess, if you're going to be banking on a testamentary trust is if they don't find your will, there's no testamentary trust. So that's another potential problem with a will-based plan.
Okay. Now that Hawaii has adopted the UPC, it seems that probate is pretty inexpensive and simple. That being the case, it seems that the best reason for a trust is as a way to avoid probate is privacy.
Privacy is maybe, to me, it's the most important reason to avoid probate. But to suggest that probate is cheap and easy is an oversimplification. Probate can be quick and cheap and easy. But if you work in this area, you know that it doesn't take much to make it drawn out, expensive, and extremely aggravating. Probate itself is a forum for a fight. When you file your petition down at the probate court, you have to send out notice to all of the interested parties being everybody who is named in the will, plus everybody who's not named in the will who would have a right to make a claim against the estate under the law of intestate succession. So what you do is you're sending out an invitation to a fight. If there's any disagreement over who the personal representative should be or who should be included and not included in the estate and all of those kind of things, that's the place that they get litigated, and that's where a lot of the problems with probate come in. So yes, probate can be very quick and easy, especially using the informal probate provisions of the UPC, but by and large, probate is a great thing to avoid, not just for the privacy, but because it can become very complicated, very expensive, very easily.
Okay. Revocable living trusts are not a good protection against creditors in bankruptcy.
Yeah, that's true. Revocable living trust isn't going to protect your stuff from your creditors. Absolutely true.
What happens in a husband and wife who uses a family trust without creditors?
I don't understand the question. Could you repeat that, Brian?
What happens in a husband and wife who uses a family trust with creditors?
Well, I think what the person is getting at is first spouse dies, family trust continues for the benefit of surviving spouse and the kids. Well, all those protections that I was talking about can be built in at family trust. So for example, um, there can be provision for a neutral third-party trustee that surviving spouse would have the authority to hire and fire at will. Um, so with using separate revocable trusts, we can build some really neat creditor protection. If the point of the question was, well, what if they're using a joint trust? By drafting, you can build in protections that are going to require the segregation of assets between, let's say, the survivors trust and the trust of the first to go. And so through drafting, you can essentially make that joint trust divide into separate trusts and get the same benefits that you get from using separate trusts in the first place. For most purposes, just for ease of administration, for just ease of understanding, uh, I think it's a better practice to have separate trusts for the spouses. But some spouses really want to use joint trusts, and that's fine. It's just that it takes a lot more careful drafting to build in the creditor protection with a joint trust than you would with separate trusts.
What did you mean TE protection continues if placed in a trust as long as magic language is in deed?
Well, when you transfer assets into when you take a tenancy by the entirety asset and put it into your trust, the conveyance instrument, so the deed, if it's the house, needs to say that you're reserving your right to have that tenancy by the entirety protection. It's important that the deed says that, because what the statute says is that you're actually transferring the tenancy by the entirety property. If you're using two trusts, you're transferring it to the two trusts as tenants in common. But you have to pretend, as long as you've got that declaration in the deed, that it's still tenants by the entirety. So it is important to have that language in the instrument of conveyance, whatever you do to get that tenancy by the entirety asset. And tenancy by the entirety doesn't just apply to real estate, it can apply to other types of assets as well. But you want to make sure that conveyance instrument makes it clear that you're taking tenancy when you put that asset into the trust.
Okay. Can a RLT be a joint tenant?
No. Joint tenant, the law of joint tenancy requires the 4 unities of time, title, interest, and possession. And a trust or any kind of entity, just by definition, can't have the same interest as an individual, because people die. Trusts don't necessarily, corporations don't necessarily. So you can't have joint tenancy between an entity and individuals. Joint tenancy is only between individuals.
Are there dispute prevention mechanisms you recommend for estate planning, wills, trusts, etc.?
Yeah, the first one being, if you know there's problems, resolve them before you die. If you know there's problems within the family, if you know that your kids don't get along, if you know there's going to be issues, figure out a way to deal with them while you're still alive. And one great way, and there are some very good mediators here in town who can help families with this kind of situation, is to actually sit down with a neutral third party, somebody like a Chuck Crumpton, or a Tom Sterling, or somebody who can help you work through the issue and have the family come to agreement before you die as to how things are going to go. And if you've got that family agreement, then the chances of things moving more smoothly after you're gone are much better. Another kind of thing you can do is build into the agreement the requirement of mediation rather than litigation if there are issues with respect to the administration of the trust. Now, that doesn't mean there won't be litigation, but at least you can direct your loved ones in the right direction.
I think that was the last question, Scott.
Okay, and guess what? It's 1 o'clock.
Well, thank you, Scott. This is Carol. That was an outstanding presentation. We really appreciate you volunteering.
My privilege. Thank you.